Hi, everybody. My name's Kristen Prinz. Today, we're going to be talking about restrictive covenants, the legal trends, how to negotiate them, and hopefully, I'm going to give you some drafting tips. As I said, my name's Kristen Prinz. I am the founder and managing partner of the Prinz Law Firm. We are a boutique law firm that focuses on employment law, and we typically represent both employers and employees. Let's start with an overview of non-compete agreements. I do want to say throughout most of this program, I will be using the terms non-compete and non-solicitation interchangeably. When I'm speaking specifically about one or the other, I will reference the specific agreement. So a non-compete or a restrictive covenant clause prohibits an individual, usually from working for a competitor. A non-solicitation clause prevents an individual from soliciting a company's employees, clients, vendors, or other important business contacts. While we're primarily going to be focused on employment agreements, these clauses can be seen in equity documents, which I consider part of the employment agreements, and in non-employment situations. So in master services agreements, sometimes vendors are trying to prohibit their customers from soliciting employees. We see them in merger or acquisition agreements. And in those cases, they can oftentimes be a bit broader. So they are applicable beyond employment situations. There is no federal law regarding restrictive covenants. Each state really treats them pretty differently. A few states actually prohibit them altogether. Federal agencies do attempt to limit businesses from engaging in anti-competitive behavior. So if a restrictive covenant crosses that line, it could implicate federal law. Let's start by talking about non-competes in employment contracts. So as I said, a non-compete agreement is an agreement that attempts to limit an employee from going to a competitor. It really tries to limit where an employee can work. It is estimated right now that 1 in 5 labor force participants are bound by a non-compete. It's meant to, protect the employer's interest in its employees, but also in its customers and confidential information. If it becomes too broad, it could be considered a contract that restrains trade. I mean, by its very nature, a restrictive covenant is a restraint on trade. So a restraint on trade is void because it injures the public. But so long as it's reasonable and supported by consideration, in most states, it will be enforceable. We will talk about some of the states where it will not be enforceable today, but most states do still enforce them. And as we said earlier, sometimes when an employee is starting employment, they say, oh, I don't have a non-compete because it's not in the actual employment contract or in the offer letter. I would always advise a client to ask for the equity documents if they're getting any equity grant, because many, many times we see these kind of buried in the equity agreements. So let's talk about some state restrictions. As we said, non-competes are restraints on trade and can be void against public policy if they do not meet court requirements. Most courts are going to require that a non-compete is supported by independent consideration. Non-competes are often looked at as independent contracts. So even though they would be part of an employment contract or an equity agreement, it is considered a bit separately. And so you would be doing your employer clients a favor, making sure that consideration is carved out in exchange for the restrictive covenant. Many employers, and historically most employers, had provided employment in exchange for the non-compete. But because most states are at will, employment started to look pretty illusory. So restrictions have been put in place to ensure that there is real consideration given in exchange for the non-compete. For example, Illinois recently passed a law that requires either 2 years of continuous employment after the agreement is signed. So even if the employee was employed many years prior, the employment consideration has to be post signing the restrictive covenant.